Hello and welcome back for our next session entitled Legal Implications of AI in Health, Safety and Wellbeing. We are joined today by Chris Green, who is a partner at Hadaway LLP. Chris specialises in regulatory compliance and investigations and brings more than three decades of experience advising businesses on health, safety and environmental matters. His session will provide invaluable insights into how organizations can navigate complex regulatory landscapes and strengthen workplace safety. Chris, over to you, sir.
Thanks very much indeed, Steve. Good afternoon, everyone. I'd love to be able to see you, but I'm afraid I can't. But the advantage is that I'm told you can't see me either. So trust me, you're not missing out on much. I hope you will be able to see the slides which I'm sharing. If not, please do put something in the chat and somebody will tell me separately. Apologies for the slight delay. We've been trying to get video and it hasn't happened just yet. How ironic then that we're about to talk about the implications of AI and how technology may or may not assist in your workplace. So without further ado, let's hope that the slides do turn over and we'll see where that goes. A little bit about me. I'm Chris Green. I've joined Hadaway, which is a full service commercial law practice out of Birmingham. The team that deal with regulatory matters with me have done it almost as long as I have, and some of them even have the grey hair to show for it. So similar to Sean's background, go around doing a lot of board presentations. I'm there when accidents take place, and a lot of it these days is advisory, where you've got matters of food, fire, inquests, transport, environment, safety and health, which of course is what we're here about today. So a little bit of context just to put this into some form of focus for you. Everyone on the call will remember the case of Polyflor. It's now over 10 years old, and this is the unguarded machine where if the poor injured party had tried any harder to bring about the injury, he couldn't really have succeeded. And of course, after the company was convicted and it appealed, it got a judgment that suggested that there is always a requirement for a hard physical engineering control before you ever rely on human error. And wherever you can take the possibility of error out of the workplace, then that's the law. And it's only when it isn't reasonably practicable that you can rely on some of the lower measures in the hierarchy. Contrast that with a more recent decision of Tata Steel, where although the fact that you've never had an accident doesn't mean that you are bomb-proof and can't be prosecuted by the Health and Safety Executive, it is of course one of the factors that are to be considered in relation to how far you quantify the level of risks. Why are both of those two issues relevant? We'll come on to it in a moment in the AI context. I actually thought I'd do a bit of an experiment in the build-up to this seminar, and I typed into one of the leading AI tools, one of the websites, risk assessment in an automotive manufacturing company, and I asked it to generate me one. Well, it was absolutely fine. I was quite impressed with it as far as it went. But then at section 5, when it said existing control measures, I know that some of this AI is pretty intuitive, but I'm not sure how it could ever understand what precautions you've actually got in your own business. So the risk for a cut and paste job and you implementing something that just doesn't apply in your business, I think is enormous. And you could probably envisage that some of the smaller businesses may already have done that. We've got, as we all know from good old HSG 65 and others, the hierarchy of measures. And where this becomes relevant in this context is this. If you're able to get some business operation done by AI, I'm afraid the inevitability, like it or not, is that increased automation and more AI tools in the workplace are going to lead to fewer employees. It is as simple as that. And by definition, of course, that means that you are making things safer. Fewer people will be put at risk, albeit workplaces, as Sean was saying, will have to adapt to that and deal with it in their own way. Now, you, as a safety profession, got some of your companies and the boards and the leaders and the decision makers through COVID, didn't you? And that's, I think, really a bit of a watershed for me. That's when we were going around advising companies about the COVID procedures, but boards really started to get interested in how they could eliminate these risks if they were able to buy a new machine or some new technology or some manual handling solution. They suddenly got very interested in that. And I suspect from the conversations that I have going around boards, if ever there were something that had the added benefit of improving safety and reducing costs, some of them are really still quite keen on that. Even now, provided they work pretty well. From a personal perspective, just to show that I'm completely impartial, as the father of somebody who's just spent for my daughter to spend 4 years on a university degree in translation interpretation, to find out that the latest ear pods from Apple, I am told, hopefully reliably, will allow you to just speak in your own language and then miraculously it will translate to the language that you're speaking in. I think going forward, graduates and architects in particular, I'm told, for some reason will be impacted by AI. There will be fewer people in the workplace. There is no doubt about that. And you've got to be modifying your safety procedures accordingly, even though there will be, as I say, fewer people affected. We're going to come on in a moment to some good practice, but always have in mind Section 36, very rarely used, but you'll know under the Health and Safety at Work Act, if the fault that's actually led to an accident has been caused by the act or default of a third party, then that person can be prosecuted in the same way that your business can, even if it's ultimately happened on your watch. You don't need to have a prosecution against the host employer. Whoever's actually caused it conceivably might find themselves in the dock, and that'd be relevant to some form of new solution, some new machinery. We see this in the context of asbestos surveyors, etc. So the way you would play that is by saying, well, we've got the sort of market leading equipment out there and the best technology available. We think it's absolutely foolproof, but if we're wrong on that, actually it's not our fault anyway, and please go after the consultant or the supplier of the machinery. So what's reasonably practicable? This will be fascinating for the lawyers over the next few years, because no one wants to deter anybody from having a go and trying to get something new and trying something from a sort of AI technology background. Whether or not it's reasonably practicable, I suppose from a cautious defence lawyer's perspective, do you want to be the first person to actually try this if it hasn't been fully verified and you haven't got a body of evidence to suggest that it's actually reliable? But again, the good news is that wherever there's anything mechanical or an unforeseen or unexpected glitch or a defect, usually the health and safety executive are pretty sympathetic to that. And even if they did prosecute you, juries are even more sympathetic. If there is nothing more you could have done, you're entitled to an acquittal, and my advice would be to defend it in the appropriate case. So here's the case study. I was trying to think of the best example I've come across. This is a case, obviously, no names, no pack drill. A client of mine operated a number of hotels in which they had swimming pools, and they were really interested in some of this new underwater camera drowning detection systems, and they installed one at great cost. Trialled it really extensively for months before they went live with it. The idea was that underwater cameras would give about 6 or 8 different angles of each corner of the pool, and reception staff, while they're checking people in and out of the pool and giving them towels, etc., had various TV screens that you could see this footage under the water. But not only was it started out as just a view of CCTV, the developers came up with something that I thought was really creative, very impressive. The functionality of it was improved because the AI would actually detect movement. So, for example, if a swimmer wasn't moving for a period of, I think it was 10 seconds, you got this coloured box generated, at which point, of course, the person on reception was supposed to look on the screen and check that they were all right. But it went better. If for whatever reason the swimmer was in a certain position and didn't move, then you'd get an audible alarm as well. Now, again, just to really demonstrate this in the context of what we're about in AI at the moment, the designer and supplier of this equipment had virtually every bit of intelligence you could possibly wish for going back years on every single drowning there had ever been. And apparently, the headline was, if you're going to drown, you'll be in one of two positions: you'll either float or you'll sink. And my client, clearly within the confines of being safe in the pool, as I say, tried this out with every different scenario, checked that it was working, and it was working perfectly. Suffice it to say, I'm afraid, I got the call after the fatality because a guest ended up being motionless on the surface for 5 minutes. But the trick was, I'm afraid, that this poor guest, well, she wasn't floating just on the surface and she didn't sink to the bottom. So, of course, straight away, what is the AI going to do about all of that? At the inquest, the coroner was very interested in how all of this worked because this was technology that was really leading and advanced, probably ahead of the field. And it was found that it wasn't 100% accurate, but equally it was pretty damn close. And of course, this was to be augmented by the people employed there having a look every so often at the screen. So the key point really to bear in mind here is you can't rely on these systems to the point where you just stop doing what you're doing. The receptionist couldn't just say, well, it's fine, it's really good technology, it'll alarm if there's a problem. We've still got to undertake the same inquiries that you would be doing prior to rolling out the technology, and you mustn't dispense with that, which again may be a difficult thing for some boards to hear. But fine if you are using this as an aid and an assistant. What you can't do, in my view, based on some of the technology at the moment, I don't think you can dispense with that human element altogether. And of course, not only was this glitch, if you will, that we've got the one scenario where I'm afraid our poor guest didn't meet the sort of classic definition of drowning. But equally, what if it's dark that day? What if there's glare from the sun? What if the costume colour is lost against the surface of the water? The water's cloudy, or any other of those scenarios. I think there is a real danger that businesses may rely solely on this technology and that AI will do it for them, because commercially that's what you're looking for, isn't it? But of course, we all go back to our duties under sections 2 and 3. We can't really do that. So dispense with some parts of it, but you can't get rid of it altogether. And again, to demonstrate the point, if I tell you that there was a really unusual case reported last year, the message is, although it's valuable, use it sparingly, but you must keep this oversight. If I tell you that unverified AI can lead to some pretty severe consequences, this case is one that you really might want to have a look at. Somebody from one of the parties in that case used AI to generate the skeleton argument and the bundle that went to the judge. And of course, tragically for that legal party, it came up with a whole host of legal authorities, case law, that didn't exist. Well, of course, the other side spotted this straight away and pointed it out to the judge. You can imagine the comments weren't too complimentary, and whoever it was that had been preparing this, not in the old-fashioned way and looking it up through the textbooks, but by using an AI tool, didn't come across terribly well at the end of that cost. And I think costs were awarded against them, and I think the case was thrown out. So rely on it to a point. It's helpful as a signpost, but please do not do this to the exclusion of the sort of test that you would be looking for ordinarily. So again, going way beyond some of the strictly legal, as support for the theory that it isn't quite there, in my opinion, yet. It isn't totally accurate and reliable. BBC carried out a survey in February of this year and found out that over half of the facts that are purporting to be put forward by AI are not actually true. they're inaccurate, they're in the wrong context, or they're just patently false. Until that figure gets higher, I'm not sure how far you can really rely on AI if what you're doing is trying to get it on a fact-finding mission. And let's face it, that's probably what we do use it for quite a bit these days, isn't it? It's almost a substitute for Google. I can see it has a role in the analysis and the interpretation and to get data processed, but do not rely on it for the moment necessarily to get you the information that you're looking for. I gave you the example earlier of the automotive manufacturing company. I'm not sure that's quite there, but there are certainly parts of it that could be used. You go back to the case I had previously, that was local authority enforced. If anybody on the call is part of a primary authority scheme, you'll know that a local authority will, in effect, pass and approve your procedures. I'd be fascinated if you have a chat with them about how far something that's AI based would actually get their seal of approval, because when it does, I'd imagine everybody in your sector and beyond will be very interested in how far that's been successful and how far the council was prepared to sign it off for you. Various other examples which are more anecdotal. You know that by pure coincidence, while a British player was playing at Wimbledon this year, the artificial line judge that they've introduced was switched off, so she won the point when the ball was clearly out. Something I caught in the preparation of this seminar, apparently there is a lawsuit in the States where an AI tool, which is supposed to be all very healthcare and advisory, advised an individual chap to eat far more salt. You can guess how that one ended. I asked my AI chatbot, what's the most dangerous or risky industry sector? And I was half trying to fool it because I thought it would say construction or agriculture or waste. And in fairness, it did say, well, it does depend on how you define most dangerous or risky. Are we going on industry rate or number of incidents? You will have seen some of the things floating around on social media where statues go walking and Putin and Trump end up dancing around a Christmas tree, etc. If people can do that and make it look that realistic, I think we really do need to take a bit of a step back as to the accuracy and the validity and the truth of some of these things that you're seeing AI generate at the moment. When all is said and done, all AI is producing at the moment is a prediction. It's not a fact. If that were otherwise, of course, you might as well dispense with the judiciary. You could go the whole hog, couldn't you? You could have an AI chatbot as the trial judge for any civil and criminal case. Well, heaven help you if you're a defendant in civil, because I think they're almost always found in favour of the defendant, and statistically AI, I'm sure, would find liability in virtually all cases. But as we know, in criminal cases, the health and safety executive's conviction record is pretty similar. It's into the 90%. So if you're in that 10% or perhaps less where you've actually got a defence and you want to run the case, please don't just go on percentages. You've got a decent defence, and we've seen during the course of 2025, certainly in my caseload and others, there are a number of cases where people are being acquitted, cases are being dropped, courts are finding in favour of the defendants in a way they never have. So the tide is turning on that a bit. But as I say, statistically, there are still an awful lot of convictions in this space. Please don't ever, for now, try out AI in terms of assisting in your accident investigation. Firstly, because it's unlikely to be privileged. Secondly, it would be a prediction. I'd be fascinated to see how far that's of any assistance to you at all at the moment. So those are all just personal opinions. In the very short time that remains, if I can flag up that the HSE have done a paper recently in relation to their use of AI and how it could assist going forward and how it's currently being used and how accurate it is. It's on the website. Those are the sectors that they've identified where they're rolling it out and trialling it. I suspect they might still be looking for other people in other sectors. If you want to be the guinea pig and blaze a trail on any of this, do get in touch with them. If you need the chap's details, I can put you in touch with the chap that was behind the paper. But that's where they're up to, and they are analysing a lot of these sort of factors already. They're looking at the different aspects of both safety management and business in general, how that's going to impact over the next few years, and in particular in relation to some of these matters, and on maintenance and surveillance and everything else. So beyond that, then I think I'm probably coming to the end of my slot. And unless my video has suddenly started to work during the course of this session, I apologise for that. But if anybody wants to turn up the reference, it's the HSE's regulatory approach to artificial intelligence, and it's hot off the presses. It's a decent read, and it only runs to about 10 pages. There is more on that in the slides from my firm, if anybody's interested, just in bullet points. But again, I'm not sure it lands a punch or any huge conclusion. It does go into the human factors. And as I said, that's the bit where I think we really do need to focus on whether people are over-dependent on AI or are becoming over-dependent on AI. So that's the future. I'm sorry if that sounds terribly cynical as a defence lawyer, to suggest that we're not quite there on AI yet. But there are some really good examples, and the drowning equipment is one of them. There are plenty more out there. But please ensure that you have absolutely road tested this extensively, and that you've been fully aware of its limitations before you actually try even to launch that in front of your board, let alone roll it out in your workplace. You would be disappointed and surprised if a lawyer didn't finish with a disclaimer, so there it is. These are personal observations. I apologise if any of that's controversial or if I've offended anybody. That certainly wasn't the intention. But if you wanted to run any of this more past us, then I think the details are in the pack. Or if they're not, then here they are again. Thank you for your time. I'm sorry I couldn't see you, but I hope that's been helpful.
Thank you very much, Chris. A very helpful session indeed. Our audience, if you would like to put some questions in the QA button at the bottom of all of your screen, we do have a few minutes left if you want to pose any questions to Chris. Okay, well, just left for me to say once again, thank you, Chris. Thank you for your time, your expertise, and for those that are going to continue with our sessions today, we have a break now. We will resume at 20 to 4. That's 15:40, where we've got another panel session discussing how we can upskill people and bring them with us as AI transforms our work. Thank you.